little dyslexic there. Okay. So again, there are going to be folks who say this is never going to happen. Nobody is going to engage in environmentally responsible behavior unless they have to. And yet, there is evidence of private parties that engage in pretty environmentally responsible behavior on their own. And the question is why? Okay. Well, with companies, we see that there has been this trend towards adoption of environmental standards for how the businesses operate, in part because consumers like that. It is partly a marketing strategy. It's also in part because a growing number of executives in these companies are people who just kind of care about the environment, right? They don't want their kids to grow up in some sort of toxic wasteland, right? And they're people too, they have kids too. I mean, it's not all just sort of profit machinery. So we see evidence of that. We see, and that was in one of the readings earlier. There's Walmart, what they're doing, and so on and so forth. There is the potential that some of this is actually not much action, it's a lot of hype. That's what's called greenwashing. Greenwashing is the sort of where the company says, hey, we're doing all these amazing things, but in reality, it's not that amazing, it's not having that much effect, they're just trying to get credit. Okay, so that happens. And yet, at the same time, say, for example, just in the realm of climate change, some of the biggest reductions in greenhouse gas emissions are coming from purely voluntary private action. I mean, that just factually, that is true. That doesn't mean that we don't need regulation. It doesn't mean that's the answer to everything. But I'm just saying factually that is a correct statement of what's happening. And so it tells us that it's not the case that environmentally responsible behavior by private parties never happens, right? That is not true. Okay? But nonetheless, even when we're talking about corporate behavior, there's some motivation, right? I mean, it's really generally not just purely altruistic, right? Mother Teresa is not running all the companies of the world or doing all the ranching or something. There's something else going on. So one of the things that we're looking for, we talked about, was very common in the second generation of environmental law, is incentives. Incentives for private environmentally responsible behavior. Well, one, tax benefits, financial support, assistance, benefits, technical support, assistance, benefits. Right, so obviously tax law shapes people's behavior. If they can get some sort of tax break, that might incentivize them. If they can get money to engage in environmentally responsible ways. So earlier, and we're going to come back again to this in the next problem, but farmers we talked about this with the Dust Bowl, farmers get a fair amount of basically just money from the government, from the federal government, to engage in environmentally responsible farming, sustainable agricultural practices that have conservation benefits, and they have demonstrable conservation benefits. And so farmers like that because it helps them meet their cost and meet their bottom line. They also get technical support. They get people showing them how to do it. If you want to plant a vegetated buffer strip between your field and the stream, in order for your fertilizers and pesticides not to run off into the stream, you need some help. What are you going to plant? How wide does it have to be? And what kinds of things? And do you have to water it? And so on and so forth, right? And so you need experts to help you do that, to tell you about that. So some of this all comes together with conservation easements. Okay, so conservation easements are basically voluntarily agreed to restrictions on how the land can be used in order to protect environmental conservation purposes. They can be used to protect other kinds of purposes, historic preservation, okay, some other kinds of things like that, facades and special artwork. But what we're concerned about is the environmental conservation. Okay? Conservation easements are negative easements. They are restrictions on using the land in any way that interferes with the environmental conservation purposes. So, like for example, if you have this wetland, the subject of environmental conservation or subject to conservation easement, you can't go build a wall on the wetland, right? That's obvious, right? So it's going to decrease the value of the land because the land with a wetland on it has less market value than land with a shopping mall on it, right? Okay? In terms of just fair market value. And so the difference between that, why is it that anybody would do that? Why would they make their land less valuable? Because they get the tax benefits. Okay? They get tax benefits, and they get tax benefits that have both income tax elements to it and estate and gift tax elements. Okay? Now, the estate and gift is arguably a little less relevant now that we have very little real estate and gift tax anymore going on, right? I mean, big exemptions and so forth. But nonetheless, it's important and so forth. And actually, in a lot of states, there are also property tax benefits. Under state law, there's property tax benefits because now the property gets valued on the tax rolls at a lower rate, so that means less tax gets paid on. Okay? So income tax, estate gift tax, and property tax. The Internal Revenue Code expressly authorizes this, the tax part of it. Conservation easements are negative easements in gross. They're held by some entity, not a neighbor, right, not the next door neighbor, so that's their gross. They're negative because of restrictions. Those are not allowed by common law. So instead, states have adopted state statutes, state legislation has adopted state statutes authorizing conservation easements as a matter of state statutory law. So, and I have not checked, the article we had said every state will only have them. Why we might have them now? I don't know. I can't tell you the answer to that. But all or virtually all of the states have them, so they are authorized by law, and the tax benefits are authorized by the Internal Revenue Code, and also in some cases by state law as well. The Internal Revenue Code, though, requires that conservation easements be granted to a qualified land trust in order to qualify for the tax benefits. And the valuation has to be done by somebody who is specially certified to do that kind of valuation. These are changes that have been made over time, and it was because developers would create their own land trust and put development land in the land trust in order to get tax benefits when there was really no conservation purposes being served. Okay, so it's cheating. I mean, it's right. Just go online every do, but there's cheating going on, and so the IRS and Congress tightened it up. Okay, so qualified land trusts can be nonprofit organizations like the Nature Conservancy, okay, or they can be governmental organizations. There's the Jefferson County Land Trust, which is a governmental entity. The state Ag Department, Kentucky's Ag Department, has what they call the PACE program, which is, I forget now what it stands for. It's an agricultural conservation easement program. I forget what the P is. Perfect. I prefer, I can't. But anyway, but the idea is that that you can have state agencies, but you can't just go out and people can't go out and randomly create themselves as a land trust and now hold conservation easements and still get the tax. Have the landowner get the tax benefits. Okay, so there's a variety. There's a lot of auditing of that now that goes on. Okay, so that happens. Actually, I take that back. There was a lot of auditing, and then once the funding for the auditing part of the IRS got cut, there's maybe less now than there used to be. You get the idea. Okay, so conservation easements end up being a really important tool for really almost any kind of conservation action that involves ecology or ecosystems or habitats. Okay? Having said that, as you saw from the reading, there are also some constraints, some problems. One is that there is a belief by some that there's an over-reliance on conservation easements. This is all private transactions. There's no real public accountability. The property is not held by the public, so on and so forth. This takes attention away from, or resources away from government-achieved or government-mandated conservation. Again, that's going to largely depend on your particular worldview about how much this should be done by private sector versus how much this should be done by the government, right? I mean, if you are a libertarian, you are not very sympathetic to that argument. If you are a socialist, you highly embrace that argument, right? I mean, that's just start saying, bottom line, that's kind of, different people come up, the argument that the government should be doing this, not conservation uses, right? And the libertarians are like, hey, this should all be private, right? You get the idea, right? And so your worldview is going to shape how you really think the conservation easement should, how much we should be relying on conservation easement. What's a little bit less ideological and more factual is, are they achieving their purposes? Are the conservation easements really achieving conservation? A couple problems. One is fragmentation, right? It becomes difficult to have large tracts of contiguous ecosystem lands or habitat corridors that are needed ecologically and biologically to sustain the ecosystem or sustain the species, right? So you need big amounts, and they need to be connected, and they need to be connected in certain ways to have these corridors, to have these patch dynamics, and so on and so forth. And a lot of that is harder to do when you have this conservation easement over here, that one over there, this one down here, and so forth, because it all depends on a landowner voluntarily agreeing to do this. Having said that, there are some entities that are pretty savvy about putting together huge conservation efforts, huge conservation resources using conservation easements. The Nature Conservancy is one. It's the world's largest environmental conservation organization, and they do big stuff. They have, they've got this whole big thing going on over in eastern Kentucky with Daniel Boone. Well, not Daniel Boone, of course, but beyond that, but over by Pine Mountain and into Virginia and North Carolina and Tennessee, big, huge areas of forest and mountain conservation. Over on the Mississippi River, they basically have acquired what was timberland from timber companies and set them aside for conservation purposes on the Mississippi River. So back down, Jackson Purchase area, right? Everybody know where I'm talking? No, some of you don't. But anyway, way in far southwestern Kentucky, on the where we're now down to the Mississippi River, and we've got areas that are wetlands. And we're going to get this next unit, wetlands, and they need to be conserved. And so the Nature Conservancy has done that. Having said that, there are some issues. Some of you may have noticed recently, it's been within the last few months, that a lot of the top leadership at the Nature Conservancy either resigned or was let go for being mainly sexist, being very all male, kind of rah-rah, and sort of excluding women from leadership positions. Okay, it was a big problem. It was a big cultural problem, and so now they're trying to work on that and fix that. And I was on the Nature Conservancy's board of trustees for the Kentucky chapter, and over and over again, I kept hammering this point, and they obviously care about it, and so forth, and then eventually just left the board, which is that they had absolutely no people of color on either the board or the staff. Okay, for the entire state of Kentucky. I mean, that's just, to me, that's astounding. But nonetheless, they're always saying, well, these scientists, we need high wealth individuals, and there they are. So, so what I wanted to point out there is that there's some good things that happen that the Nature Conservancy does, but there are also some problems, right? So again, when you were talking about the private sector, there's some issues there. Okay, so it's not easy, it's not clear cut, right? Okay. So then finally, the last thing I just want to kind of emphasize, and then I'll spend a couple minutes talking about the outline that's due on Monday, okay? Right? Okay, but a couple minutes on just the takings issue, okay? There's two issues, takings issues and Commerce Clause issues. So what you see is a lot of private parties and private landowners pushing back against the Endangered Species Act and other sort of conservation-oriented regulations, saying this is taking my private property without just compensation under the Takings Clause of the U.S. Constitution, Fifth Amendment, right? Okay, okay. Most of you have taught for property, so if you were looking at me blankly, you were in serious trouble, right? If you do not remember that we studied the Takings Clause in property, that's I know you did, because we did, right? Okay. So, all right. But, so that ends up being an issue. The other thing is Commerce Clause issue. What about a purely intra-state, inside the state species? Okay? Does Congress have authority under the Commerce Clause of the U.S. Constitution to regulate, to protect a purely intrastate species? So far, most but not all of the cases have said that endangered species are inherently commercial in some way or another. They either substantially affect interstate commerce, they're in interstate commerce, something of that sort. Land development, is interstate commerce. It's so that they've been, that's sort of how the majority of cases have gone. That's why you have PETPO, right? That's part of the point of that case, is to get you kind of looking at that. But it's unclear. It's unclear where we're going with this because you know that the Supreme Court has tried to bring in some of the scope of Congress's regulatory authority, saying, hey, there are some outer limits to the Commerce Clause, and not everything counts as interstate commerce, right? And so who knows where this will go in the future, and especially as the personnel in the court change, I could see some purely intrastate species in a 5-4 decision be held by the Supreme Court to be beyond Congress's interstate commerce power. Maybe not, depends, but we'll see. Okay, so that's something to think about in terms of thinking about how we would try to harness private action for grassland conservation and prairie dog conservation. Okay, so I'm going to end here on Monday. We're going to talk about this problem and work our way through some solutions. We've covered a lot of law, some non-law tools and instruments as well. Okay, what the best way to organize an outline on these problems is solution by solution. Think through what some of the solutions are as assistant director, and then put your legal analysis, your little mini legal outlines under that, right? Now some of them might be copy and paste, right? So if, for example, you've got federal land management action, right? That might be challenged under the APA, right? You're probably going to have to do a NEPA analysis. Another possibility is listing the other prairie dogs as a possible solution, right? Well, that's ESA analysis. There's also a NEPA analysis with that, right? So basically, there's also an APA analysis because somebody's going to sue you over, right? No, somebody's going to sue over pretty much anything you're going to do. So you have to think through that. What's standing, etc. Okay, so some of your analysis might refer to previous analysis, or it might be copy and paste, right? Kind of stuff, right? But again, think about what you're going to do in the real world, in practice. Right? You're going to deal with multiple possible solutions, and you're going to have to think through the legal implications of each and every one of them. Right? You can't just sort of say, oh, I talked about the APA once, I'm never going to talk about it again. Right? Unfortunately, that's something I know it's more work, but something to think about. Right? But what we're aiming for here is problem solving. Think through what are some possible solutions. What are some possible solutions to the grassland and prairie dog? And they can be big categories of solutions, but that's ultimately what your client is asking you to do. Right? The client is not asking you just to excel at regurgitating the Endangered Species Act. Right? They're asking you to help them solve problems. Does that make sense to everybody? Okay. Now don't get carried away with this. If you end up having 42 possible solutions, that's too many. I mean, first of all, you couldn't possibly do all of them, but that tells me that you're making them too micro, right? I mean, you're coming up with too many little things, right? You need some bigger categories of things, right? If you come up with 2 solutions, it's too few. It's too few, right? So I think I came up with something like 8 or 10. Okay, so, okay, you do not need 8 or 10. You do not need 8 or 10. Right? Because part of the idea is just to get you moving towards going through this analysis, get you taking the next step towards where we want you to be at the end of the semester. So don't get carried away with this, but again, that gives you some feel for what's going on. Okay? Oh, and I meant to send this around. Before you leave, sign the roster. Take care.